This is the Grant Caldwell Report on current news, and tonight we are tracking a development out of Washington, D.C. that is already sending shockwaves through the political system. Before we begin, make sure you like this video, subscribe to the channel, and turn notifications on. This story is moving fast, details are emerging in real time, and critical updates may come with little warning. Here's what is confirmed. Newly released Jeffrey Epstein-related documents, made public through official channels, are now being reviewed by journalists, lawmakers, and legal analysts across the country. These materials, according to multiple outlets, include previously sealed records connected to Epstein's network, contacts, and past investigations. The release itself is not disputed. The implications, however, are still unfolding. What makes this moment significant is not just what is in the files, but what happens next. Washington is reacting, quietly in some corners, nervously in others. Because whenever long-suppressed records tied to a case this notorious surface, the consequences are rarely contained. The Epstein case has never been just about one man. It has always raised deeper questions about power, protection, and accountability at the highest levels. At this stage, officials have been careful with their language. There has been no sweeping statement from the Department of Justice declaring wrongdoing by newly named individuals. There has been no blanket confirmation of criminal exposure tied to the release, but there has been acknowledgement that the documents are authentic, legally released, and subject to public scrutiny. And that alone changes the landscape. Some names appearing in the records are already familiar to the public. Others are drawing renewed attention. What matters most right now is not speculation. It is verification. What is confirmed, what is alleged, and what is being misrepresented as fact before it has been reviewed in full. That distinction will determine whether this moment leads to real accountability or fades into another cycle of outrage without consequence. Here's the key point to understand at the outset. Document releases do not equal indictments. Mentions do not equal guilt. Associations do not equal crimes. But they do demand transparency, explanation, and, where appropriate, investigation. Tonight we are going to slow this story down. We are going to separate confirmed facts from claims, and we are going to focus on the institutional response, not the online frenzy. Because when files like these are released, the real story is often not who is named first, but who is forced to answer questions later. Here is what is confirmed at this point, based on reporting from major national outlets and official statements tied to the document release. Federal authorities have confirmed the public release of previously sealed records connected to the late Jeffrey Epstein and related civil proceedings. These materials were made available through lawful judicial processes and are now accessible to journalists, attorneys, and the public. The release itself is not in dispute. According to multiple reports, the documents include court filings, exhibits, and records that reference individuals who were previously unnamed or redacted in earlier versions. These references vary widely in nature, ranging from contact information and scheduling details to third-party mentions within testimony or correspondence. Importantly, inclusion in these records does not automatically indicate criminal conduct. The Department of Justice has acknowledged awareness of the public release but has not announced new charges, reopened prosecutions, or named new criminal targets as a direct result of the documents becoming public. Officials have emphasized that the release of records is a judicial matter and does not itself constitute a finding of wrongdoing. Several media organizations have confirmed that the documents stem from long-running civil litigation tied to Epstein's associates and estate, rather than from a newly initiated criminal case. Legal experts cited in coverage note that such releases often occur after prolonged disputes over transparency, privacy, and relevance, particularly in high-profile cases. It is also confirmed that no official list of accused individuals has been issued by prosecutors in connection with this release. Names appearing in the documents are present for a variety of reasons, including witness testimony, social associations, or administrative references. Law enforcement agencies have cautioned against drawing conclusions without context. Members of Congress from both parties have acknowledged the release publicly, with some calling for further review of the materials and others urging restraint until the contents are fully examined. At this stage, there has been no bipartisan consensus on next steps, hearings, or legislative action tied specifically to the documents. What is also verified is that the Epstein case remains a point of deep public distrust toward institutions. That context is influencing how the release is being received, but it does not change the legal standards that apply. So, to be precise, here is what we can say with certainty. The documents are real and officially released. They originate from civil court proceedings. They do not constitute criminal charges. No new indictments have been announced. Authorities are urging careful review and restraint. And with that foundation established, the next question becomes unavoidable: how these facts are being interpreted and misinterpreted in real time. As soon as the Epstein-related records became public, claims raced ahead of facts. Social media framed the release as proof of criminal exposure. Some commentators suggested indictments were imminent. Others implied that any name appearing in the documents was evidence of guilt. That is not what the records show. Here is the reality. Mentions in civil filings tied to Jeffrey Epstein do not equal accusations, and accusations do not equal crimes. Many names appear because they were referenced by witnesses, listed in contact logs, or mentioned in correspondence. None of that establishes wrongdoing on its own. Claims suggesting an official client list was released are incorrect. No such list has been authenticated by prosecutors. Reports implying coordinated federal action following the release are also unconfirmed. To date, authorities have not announced new cases, arrests, or investigative targets tied directly to these documents. What is happening is interpretation, often without context. This is where confusion sets in. The speed of online reaction creates pressure for conclusions before verification. But legal processes do not move at the pace of social media, and document dumps rarely deliver clarity without careful review. The bottom line is simple. The files raise questions, not verdicts. And the next phase of this story will be defined by evidence, not assumption. When documents like these surface, the central issue is not outrage, it's accountability. Who is responsible for reviewing the material? Who decides what warrants further scrutiny? And who ensures the public gets clarity without compromising due process? At this stage, responsibility rests with institutions, not commentators. Courts authorize the release. Journalists are tasked with verification and context. Lawmakers may call for oversight. And prosecutors decide, based on evidence, whether any legal thresholds are met. That chain matters because shortcuts erode trust. There is also a broader power question at play. The Epstein case has long symbolized public skepticism toward elite protection and selective enforcement. That history is why every new release triggers immediate suspicion, even when facts do not yet support conclusions. Institutions understand this, which is why restraint is being emphasized. But restraint cuts both ways. Transparency cannot be indefinite silence. If the documents raise legitimate concerns, the public deserves timely explanations about what they mean and what they do not. Accountability requires more than release. It requires interpretation grounded in law, not implication. The coming days will test whether institutions can meet that standard. The measure of accountability here will not be headlines. It will be actions, or the absence of them. This moment matters not because of speculation, but because of trust. When documents tied to a case as notorious as Epstein's are released, the public is not wrong to demand clarity. Confidence in institutions has been strained for years, and silence or ambiguity only deepens that divide. But accountability is not served by assumption. It is served by evidence, process, and transparency that is timely and real. What happens next will define whether this release leads to substance or simply fades into noise. Watch for official responses, not commentary. If prosecutors act, it will be deliberate and document-driven. If lawmakers pursue oversight, it will take form through hearings and formal requests, not social media statements. And if journalists uncover material that warrants further scrutiny, it will come with sourcing, context, and verification. Anything else is distraction. The public should also pay attention to what is not happening. No rush to indict. No sweeping accusations from authorities. No confirmation of criminal exposure tied to these names. That restraint is intentional and legally required. The real test now is whether institutions can follow through with clarity, or whether this moment becomes another chapter in public frustration without resolution. This is the Grant Caldwell Report. We follow the facts, not the frenzy. If you want continued updates as verified information emerges, like, subscribe, and turn notifications on. When there is real movement, you'll hear it here. Good night.